next matter to come before the court this morning is Akron Canton Advertising Cooperative LLC versus Physicians Weight Loss Centers of America Incorporated. The appellee has not filed a brief, so will not be permitted to argue today. The appellant will have up to 15 minutes to present his argument. We have read the briefs and we are ready to see the new argument.
Thank you, Your Honors. Good morning. May it please the court, my name is Brendan Friesen. I represent the appellant, the Cleveland Akron Canton Cooperative. There's one assignment of error, and I'd like to discuss three things with respect to that assignment of error. Ultimately, the co-op is seeking for this court and requesting that this court reverse the trial court's decision granting defendant and appellee Sparkle Wilson's motion to dismiss and motion to stay, or alternatively motion to stay pending arbitration. This case has been around a while. It was first filed in June of 2008 in Cuyahoga County. It arises out of, and you may or may not have heard of this, but the Physicians Weight Loss Center, it's an Akron-based franchise. It's a national franchise. They sell dietary products, weight loss programs, and there is a physician actually associated with each store. There are several located in Northeast Ohio, and the franchise agreement with respect to this called for an advertising cooperative. So those in the area in Northeast Ohio, those locations were required to participate in a cooperative. And in that cooperative, they would contribute fees into the cooperative to pay for advertising that everyone agreed to buy. Beginning in earlier in 2008, there were some franchisees that decided in the area not to contribute those fees. After demand letters were sent, ultimately the co-op had to file an action against those franchisees. They also filed the action against the franchisor, hoping to get their attention and get their participation in enforcing those requirements for those franchisees to contribute to the advertising fund.
Did those that had already contributed, we'll strike that. Go ahead. I think I understand now. Go ahead.
Yeah. Like I said, this was pending in Cuyahoga County Court of Common Pleas. It went up on appeal on one issue, two issues. It's the same issue that's before this court. One of the franchisees filed, the same franchisee, filed a motion to dismiss, motion to stay pending arbitration, pointing to the arbitration provision in the franchise agreement. And there's no dispute that that agreement does contain an arbitration provision. That's not the cooperative is not disputing that. The franchisor on this, at the same time also filed a motion to stay pending arbitration, seeking an order and a finding that the arbitration provision in the franchise agreement controlled. The co-op was not a signatory to the franchise agreement. Trial court denied both motions. Those rulings were appealed, and the 8th District decided on the issue of whether or not the action against the franchisees, which was based on the cooperative agreement, whether that action was subject to an arbitration clause. The 8th District found that it was not. That the cooperative agreement did not contain an arbitration provision, and therefore the co-op could proceed in court against those franchisees. Basically an action on an account. You guys got to pay. Those that are in arrears, you have to catch up, and you have to continue to pay. As to the action against the franchisor, the co-op, which was the appellee in the 8th District, ultimately lost, and the 8th District reversed the trial court's denial of the motion and found that the arbitration provision in the franchise agreement barred the action in court, and the co-op instructed the co-op to pursue its remedies against the franchisor in an arbitration proceeding. That established the law of the case, and that's the principal argument, one of the principal arguments in this appeal, that the trial court did not follow the law of the case. Subsequent to that, the case was remanded back to the trial court, and the trial judge addressed a motion that was filed earlier in the case, a motion seeking to transfer the case down to Summit County. That motion was granted, and we packed our bags and we shipped the case down to Akron, Ohio. And that was in December 2009. Those decisions, by the way, Your Honors, from the 8th District were in November 2009. In October 2010, Sparkle Wilson, who's the appellee in this case, she refiled her motion to dismiss, motion to stay pending arbitration, and that motion sat for the better part of 4 years. Mainly because there were a couple of bankruptcy stays that were issued on the case. I had to file a motion to lift the stay order as to those franchisees that had not filed for bankruptcy. And ultimately, we went before the trial judge on several motions that were pending, one of which was the motion to dismiss, motion to stay. And the trial judge remarkably granted that motion, finding that the cooperative agreement or this action against the franchisees was subject to an arbitration clause in the franchise agreement, which was in direct contravention to the district's finding on the same exact issue, looking at the same exact agreements. So with respect to, and we had to appeal, and we're before Your Honors on that appeal. With respect to our request to seek a reversal of that order, again, the doctrine of law of the case applies here on all four corners. The 8th District addressed this very issue, looked at the same agreements, looked at our complaint, and found that we could proceed against the franchisees in court. We're not subject to an arbitration clause. The co-op agreement stands on its own. The co-op agreement contains the rights in which we seek to enforce against those franchisees. We just want them to start paying. And I cite to many cases in our brief. Nolan, these are Supreme Court cases. Nolan v. Nolan, 11 Ohio State 3rd. Hubbard v. Saline is a case I did not cite, but I think it'd be helpful, Your Honors. 74 Ohio State 3rd, 402, giving again background on the law of the case doctrine. With respect to the co-op agreement itself, the co-op agreement does not incorporate any other agreements by reference. It has an integration clause that this is the entire agreement among the parties, and does not contain an arbitration provision. The other issue, Your Honors, is when the stay order was issued, there were defendants that we had obtained judgment against on the merits. One was on summary judgment, the other was a default judgment. The stay order was, again, issued on defendant Sparkle Wilson's motion. That order stayed my collection proceedings against those defendants. Now, with respect to the defendant Bevington, he did have a pending motion to vacate that default judgment. That was not addressed prior to that stay order being issued. But as to defendant Mohammed Grib, we had obtained a summary judgment against him in 2012, and we had been seeking to collect on it. And because that stay order was issued, we had to stop all collection efforts. So again, with respect to the cooperative agreement, we would ask that this court find that there is, like the 8th District did, first find that there is an arbitration clause, that the law of the case controls, that the 8th District's decision applied to the trial court in Summit County on the exact same issues, and that even if the court went outside or did not follow the law of the case, the cooperative agreement itself, looking at it on all four corners, does not contain an arbitration provision.
Let me just ask you, the trial judge here in Summit County thought she was following the 8th District Court of Appeals decision. She said the Court of Appeals in the 8th District said you can't accept the benefits and not give burdens as well. So the trial court originally, I don't mean to point at you, I apologize, the trial court originally in Cuyahoga County ruled that arbitration, that you didn't have to go to arbitration.
Correct, as to both claims, the claim against the franchisor and the claim against
The cooperative.
the co-op's claims against the franchisees.
Okay. And then the 8th District affirmed that?
They affirmed the ruling as to the franchisees because they found the co-op agreement stood on its own, did not contain an arbitration provision. The Court of Appeals for the 8th District reversed as to the franchisor.
And what is the, because I want to make sure I have the right case, because it seems a little confusing to me.
Mm-hmm.
What is the side on that? And was it, obviously it was introduced in
Yes.
part of our record?
Correct, it's in my appendix. The case as to the franchisees and the decision on that was 2009 Ohio 5837.
Okay.
And
I apologize. Usually, I'm not saying I'm opposed to this, but our rules provide we don't have anything, we don't put that stuff in the appendix. That's fine.
Okay.
I don't
apologize.
necessarily agree or disagree with that. It's just a matter of sometimes I don't look for those in the appendix because our rule doesn't provide for it. So it's my problem.
Okay, no, I apologize for that.
No, you didn't do any, well, maybe you did do something wrong, the rules provide that. But I'm not getting on you for that. I'm just saying I apologize, but I was looking it up because usually we don't have that kind of thing.
I see.
So go ahead.
Yeah, and then the language for that, Your Honors, at page 3 of the opinion says the co-op can maintain suit based upon the cooperative agreement, which we are doing here, and therefore should not be burdened with provisions in the franchise agreement to which it is not a party.
What paragraph is that? Because that's what we go by anymore. It makes it so much easier.
Yeah.
You have the...
It's page 3 of the opinion. It's volume 694, page 161 to page 162.
Well, we're just looking at two different versions.
Yeah, I know. I have the one that the Court of Appeals issues, and then I have the Westlaw one.
Yeah, I'm looking at the Westlaw, so that's the problem. I just go by paragraphs, and that's fine.
I apologize.
No, you don't have to apologize. I'm just looking at the wrong version. So. Go ahead.
Yeah, I can't reconcile the judge's opinion, the trial court's opinion, with the 8th District's decision. They don't comport. I don't know if she was looking at the other decision as to the franchisor. She may have been.
That's what I was wondering.
Yeah, but that one doesn't apply here. The law of the case here, with respect to the action against the franchisees, it is directly opposite to what she found, which is there is no arbitration provision. And frankly, she didn't even find that there was an arbitration provision. She just continually cited to the 8th District's decision, which was erroneous, as far as her citation to it, because the 8th District found the opposite, that there was no arbitration requirement. So again, Your Honors, just to wrap this up, on behalf of the cooperative, the appellant, we are seeking and requesting that this court reverse the decision of the trial court, find that the action can proceed against the franchisees in court in Summit County, and that it is not required to arbitrate its claims. and certainly to lift the stay as to the other defendants who are not party to this appeal, defendant Sparkle Wilson. Thank you, Your Honors.
Thank you for your presentation today. The court will take the matter under advisement and issue a written decision, which will be mailed to all parties as well as posted on the Ohio Supreme Court website. We are adjourned briefly until our next